Okay, hello everyone. Bonjour tout le monde. Euh, je suis Robin Whitaker, la présidente de l'Association des canadiennes des professeurs et professeurs universitaires du Canada. I'm Robin Whitaker. I'm the president of the Canadian Association of University Teachers, and I just want to welcome you all to our keynote, our CAUT keynote address for Fair Dealing Week 2026. We're very lucky to have David Vaver with us, who I will introduce shortly. We are also partnering with the Canadian Federation of Students. And so I think our partner representative was unable to turn up, but I wanted to mention that we are partnering with the Canadian Federation of Students on this event. Just before we get started, a couple of things to go through. If you need translations, si vous voulez la traduction en français, il y a une icône de globe en bas de l'écran. Cliquez sur More, puis il y aura une icône de globe là et cliquez sur l'icône et la traduction, vous aurez la traduction. Um, when we get to the question and answer period, there will be Mary Feltham is here from the Canadian Federation of Students. So great. Um, she's in the waiting room. Sorry. um, yes. The other bit of housekeeping just to mention is that if you want to submit questions for the speaker, you'll see the Q&A icon at the bottom of the screen, and you can put your questions in there. Those will follow the prepared remarks. So I'm just going to turn to a territorial acknowledgement now, and then we'll introduce Mary Feltham and then introduce the event itself. So although this meeting is being held virtually, we all do our academic work on specific Indigenous, First Nations, Métis, and Inuit territories. Some of these territories are governed by treaties, and some are still unceded. I would ask all in attendance to reflect on the conditions under which we occupy these spaces today and always. And I myself am at Memorial University of Newfoundland, which has campuses on traditional territories of the Mi'kmaq and the Innu and Inuit of Labrador. So I'm just going to invite Mary Feltham, the chairperson for the Canadian Federation of Students, to introduce herself. If you're there, Mary. Oh, okay. No, I'm okay. We may have to get Mary to introduce herself shortly. I'll continue on because we have a tight time frame, and we'll hopefully see Mary shortly. So just to introduce CAUT's involvement in copyright advocacy, we represent 75,000 members at over 130 colleges and universities across Canada. Since 1951, the Canadian Association of University Teachers has defended the rights of teachers, librarians, researchers, and other academic staff in Canada's public post-secondary institutions. CAUT advocates for quality, accessible post-secondary education. CAUT's members are both the creators of the majority of scholarship emanating from Canada's post-secondary sector and the users of an enormous amount of content as both researchers and educators. This makes us, as authors and users, particularly, or it enables us to have a particularly balanced perspective on copyright laws. Fair dealing is integral to ensuring balance within copyright law between the rights and obligations of copyright owners and those of users. But the importance of fair dealing as a user right and as a balance within copyright law has not always been recognized in Canada to the extent that it should be. Today's speaker, David Vaver, was integral to introducing the concept of fair dealing as a user right. His work in this area was cited in the landmark CCH decision by the Supreme Court of Canada 22 years ago, case law, which is akin to the Big Bang theory of fair dealing. um, and I'm going to introduce Professor Vaver just in a moment. But Mary, would you like to introduce yourself?
Hi, yes, thank you so very much. And thank you everyone for your patience. I think what was happening was I was using the participant link, so that's silly on me, but I'm happy to be here. Happy that everyone else had the opportunity to join. Um, my name, as was mentioned, is Mary Feltham. I am the chairperson for the Canadian Federation of Students, and it is an honor to be here alongside the folks from CAUT to celebrate Fair Dealing Week and to hear more from Professor David Vaver on today's keynote. For folks who might not be aware, CFS represents over 500,000 students advocating for accessible, high-quality education, and we fight for students' rights, working towards creating a more equitable and inclusive post-secondary education system across so-called Canada. And fair dealing is a crucial right for students, educators, researchers, librarians, and the broader Canadian public, allowing them access materials and works for educational and research purposes without the risk of copyright infringement or costly royalties. And the importance of fair dealing will continue to grow in the coming years. And this is especially true as we are in a critical point with our post secondary education sector, which has faced some pretty significant economic challenges. And even in recent weeks, we have seen announcements of cuts to funding programs on top of all the program freezes and budget cuts that we have seen across universities and colleges. And this financial instability stems from decades of underfunding. It is essential that our elected leaders step up and provide much needed leadership and financial support to ensure that all post secondary institutions continue to provide high quality, affordable education to students. And if you are in the Toronto area, I encourage you to look up the work that the Ontario component of CFS is doing to advocate for accessible education and restoring of funding, especially the March 4th rally. But today, the discussion on fair dealing and the right to research is particularly relevant to the CFS grad students, and many are involved in groundbreaking research and works in labs contributing to the advancements of science and innovation. These students are at the forefront of education and research, helping shape Canada's future workforce and researchers and innovators. A big thank you to all of CFS's Solidarity partners, including professors, educators, librarians, and copyright advocates who are tirelessly working to protect fair dealing for future generation of students. Your efforts ensure that all Canadian copyright laws are not rewritten to serve the interest of large, multi-billion-dollar textbook publishers, but instead protect the rights of those who use educational resources. Thank you. I can hand it back over to Robin if there's any other things she would like to say before our keynote. Thank you.
Thank you. Thanks. Thanks, Mary. Well, all that remains is to introduce David Vaver himself. So David Vaver is CM at FRSC, is Emeritus Professor of Intellectual Property and Information Technology Law at the University of Oxford and Emeritus Professor of IP Law at Osgoode Hall Law School at York University. He's well known for his expertise in IP law, and his extensive writings have been widely cited internationally in the scholarly literature, as well as in Canadian courts, including the Supreme Court of Canada. He founded the Intellectual Property Journal in 1984, from which he retired as editor in chief in 2016, but remains on the advisory board. He's a fellow of the Royal Society of Canada and was appointed in 2016 to the Order of Canada. Uh, and that was for his leadership in intellectual property law as a scholar and a mentor. A new edition of his book, Intellectual Property Law, Copyrights, Patents, Trademarks, the second edition of which was published in 2011, will be published in 2026 by the University of Toronto Press. So once again, we're very lucky to have Professor David Vaver here to give us our keynote speech, and I will hand it over to David to start the presentation. Thanks so much.
Well, thank you very much for those remarks, Robin, and thank you very much, Mary, for those remarks relating to the importance of this subject for students. So thank you for inviting me to talk at your Fair Dealing Week. It's interesting that a subject which just took 18 words to describe in Canada's Copyright Act in 1924 should, a century later, have become one that takes a week to talk about. But so it often is with a few short words found in legislation. The right to freedom of expression that appears in the Canadian Charter of Rights and Freedoms takes just 24 words to express, but it too has generated discussion out of all proportion to the Sibylline language in which that freedom is expressed. Fair dealing now runs into 3 short sections of the Copyright Act, but there are, of course, other much more elaborately expressed user rights that occupy a sizable chunk of the Act, including those dealing with the activities of today's educational institutions, libraries, archives, and museums. User rights talk has been common currency in Canada for the last couple of decades and is becoming more so internationally. I propose today to talk about how and why such rights arose and some future challenges to them. Some matters are being covered more fully by other presentations, and some of what I say may be old hat to some of you, but I hope not all. And I do hope to provide the ancient headgear with the occasional new feather. First, what are user rights? Well, broadly speaking, they're the rights that anyone has to use a copyright-protected work or performance without interference from the copyright owner. Elsewhere, this ability is called an exception or limitation to copyright. Indeed, the rights appear in our Act under the heading of exceptions. But Shakespeare notwithstanding, a rose by any other name does not necessarily smell as sweet, and so it is with our subject. An exception to copyright is not the same as a right to use a copyright-protected work. Fair dealing is the most discussed user right because it cuts across all of copyright and sets the tone for the way that the other rights are interpreted. It reflects a norm commonly expected of all human social interaction. Do unto others as you would have them do unto yourself. Fair dealing and the other user rights represent copyright's golden rule. In the initial Copyright Act of 1924, fair dealing stood at the head of 5 user rights, all of which are still with us a century later. It continues to occupy the same pride of place because it applies not just to literary work, music, art, drama, and movies, but also to what the Act calls the other subject matter of copyright: sound recordings, broadcasts, and performance rights. It overlays the specific user rights the Act details, the rights of non-profit educational institutions to serve their faculty and students, and of libraries and archives to serve their patrons, as well as other rights. Access rights for people who cannot see or hear well or at all, for charities to further their aims, for places of worship to use music in their services, and so on. Some activities that these specific user rights do not catch may yet qualify as fair dealing or may be otherwise justifiable in the public interest, a subject that I'll mention a bit more fully later. Fair dealing and the public interest defense function as sorts of backstop. In the spirit of your week, I shall concentrate on the user right of fair dealing, utilisation équitable in the French version of our Act. The provision on fair dealing came into our law and the laws of most countries of the then British Empire from the 1911 UK Copyright Act, although the right has been much tinkered with since. The US has its counterpart, fair use, which is like fair dealing in some ways and not in others. For example, the US Copyright Act sets out what factors to consider when deciding whether a use is fair. Canada's Act does not do that, but our Supreme Court has given guidance on what dealings are fair along similar lines to US law. But fair dealing in Canada is allowed only for 8 purposes: research, private study, parody, satire, education, criticism, review, and news reporting. While in the US, use for any purpose may qualify. Canada also has what we can call an attribution tripwire. If you copy something for the purpose of criticism, review, or news reporting, you must acknowledge your source. Otherwise, the dealing will be categorically unfair. Not so in the United States. What is legal in one jurisdiction is quite often not so elsewhere. Take the case decided a few years ago where Canadian courts said that the unauthorized copying and sale by an Alberta-based company of a code of electrical standards produced by the Canadian Standards Association, the CSA, was not a fair dealing because the whole code had been copied and was being sold at a lower price in competition with the CSA product. And so the company was infringing the CSA's Canadian copyright. The company responded by moving its business to Texas and selling online from there. And the CSA lost its bid to close down the American operation. One judge on the US Appeals Court deciding the case said that the company's use was not fair under US copyright law for much the same reasons fair dealing failed in Canada. But the majority of the court did not consider fair use at all and said instead that a code that was incorporated into law, as the CSA's code had been throughout Canada, was effectively legislation, and legislation was free for all to use under US law, even where it emanated from a foreign country and was protected there. Last time I looked, the site continues its marketing from Texas, accompanied by a backstory of how a little guy from Alberta triumphed over bullies from the Canadian Civil Service. Let me return to the issue of nomenclature, the treatment of fair dealing and other facilities to use copyright protected material as user rights. The word right here is used in its common meaning of entitlement, like the right to vote. Why does calling these things user rights rather than exceptions and limitations matter? Why fight over a label? Because words matter, and nowhere more than in law. They orient how courts, lawyers, and the public think about a subject. Those who talk of exceptions rather than rights are really claiming that copyright's natural order is one where all uses are or should be within the copyright holder's control, and that any departure from that position is exceptional, an abnormality or aberration. From there, it's a short step to call copyright property, just like land and goods are, and to say that anyone doing anything a copyright owner doesn't like is taking their property. Maybe the taking is not unconstitutional, but it at least should be considered exceptional, to be closely cabin cribbed confined, as Macbeth puts it, and interpreted as narrowly and grudgingly as possible. Copyright can be analogized to land in some senses. You can sell or license it or bequeath it in your will. In other ways, the analogy falls apart. How can you be tossed off a copyright the way you can be tossed off land? If I dig up and carry off your rose garden and throw it in the sea, it's gone. You don't have it anymore. Copyright has no equivalent. If I infringe your copyright, you still have the right. And sometimes an infringement may even make it more valuable. The fact is that copyright is a social institution, not a natural right. It needed Parliament to pass legislation to create it, and the content of that statute has changed radically over time as technology and society have changed. What the English Parliament passed in 1710 as the first copyright law dealing with the printing press does not look anything like the copyright law sitting on any country's books today in the age of electronics. Before copyright came along, people could do whatever they wished with published work. Copyright was a fetter. It was the exception, and freedom from it was the rule. That was how copyright looked up to the early 20th century. Users had plenty of rights because copyright owners had so few. In those simpler times, when tableaux vivants were a common form of entertainment at fairs and exhibitions, I could stage a tableau vivant of Manet's painting, A Bar at the Folies Bergère, without bothering to ask Manet or pay him a sou. Charles Dickens could stop Great Expectations being staged as a play only by himself simultaneously publishing a stage version of it. Otherwise, he had no expectation, great or small, of stopping anyone else from putting on the work as a play or getting royalties from the performance. For 19th century laws did not give novelists the exclusive right to dramatize their work. Not only did owners have few exclusive rights, but judges interpreted them to say that there was nothing wrong in using work in ways that were not unfair. What was fair was a value judgment that depended on not just how much and what was taken, but why it was taken and what additional value arose from the taking. So, abridgments, criticism, and even translations were allowed because the abridger, critic, or translator had given society something new and valuable that didn't exist before. In one striking English case at the end of the 18th century, a map maker had produced a nautical chart of the east coast of North America, running south from the Strait of Belle Isle between Newfoundland and Labrador. He had done so by copying and consolidating 4 charts made by another cartographer, who then proceeded to sue him for infringement. But at the trial, the second map maker brought in 2 mariners and an astronomer to testify that there were not only substantial differences between the charts, but that the new one had corrected some dangerous errors in the earlier ones caused by the failure to observe the principles of Mercator projection. Apparently he was another flat earther. One particularly interested witness was Admiral John Campbell, the governor of Newfoundland, who said the plaintiff's charts were so bad that they all should be burned and their printing plates destroyed. In those days, infringement trials were often tried with juries, and the jury here was directed by the Chief Justice of England, Lord Mansfield, to steer a course between, now I'm quoting, 2 equally prejudicial extremes. On the one hand, not to deprive those who have employed their time for the service of the community of their just merits and the reward of their ingenuity and labor. On the other, not to deprive the world of improvements or retard the progress of the arts. He made his own views clear on the merits of the case. Quote, "If an erroneous chart be made, God forbid it should not be corrected even in a small degree if it thereby become more serviceable and useful for the purposes to which it is applied." Unsurprisingly, the jury exonerated the second map maker, as one hopes he would be exonerated today. We're no longer in the 18th century, and the right to stop dramatization, translation, abridgment, 3-dimensional copying, and the rest was handed to copyright owners by legislation in the 20th century. Mansfield's words, nevertheless, continue to resonate. Copyright may have grown and intensified, and user rights may have shrunk, yet no reason exists why both owner and user rights should not be given equal weight and respect. For without users, what's the point of copyright law at all? Users are just as important to the institution as are authors and copyright owners. They therefore deserve equal treatment, and that means balancing right against right, not right against exception. Right against exceptions starts the balance off with a big foot on one side of the scales. Yet that big foot came to dominate Canadian law right up until this century. The Supreme Court of Canada itself said in 1990 that copyright had but a single object, the benefit of authors of all kinds. Not a word about users. And the lower courts took it at its word. In 1995, a court had to decide a case between the Michelin Tire Company and a union, which was trying to organize labor at a Michelin plant in Nova Scotia. The company said the leaflets the union was distributing to workers infringed the copyright and the Michelin Man logo by picturing him with a foot raised, ready to stomp on a worker's head. Union said it was parodying Michelin's anti-union stance, and this was fair dealing. The court ruled against the union, calling fair dealing an exception to copyright infringement and saying it should therefore be strictly interpreted. The judge refused to accept parody as a species of criticism. If parody was a purpose for which you could deal fairly, why was it not specifically mentioned? The union fell over the attribution tripwire too. It had not acknowledged the source of the logo, as if this could not be discerned from the liberal peppering of the Michelin name throughout the leaflet. The Michelin case was not appealed, but almost everything said there about copyright, fair dealing, property, and the Charter was probably wrong in 1995, and it's certainly all wrong now. It took just a decade and 2 Supreme Court cases to deflate Michelin. One was a case called Théberge against Galerie d'Art du Petit Champlain, which dealt indirectly with user rights by deciding that an artist's right to prevent reproduction of a poster of his could not stop a gallery from using a chemical process to lift the image physically off the poster and transfer it to canvas, leaving the poster blank. The court, along the way, echoed Mansfield to say excessive control by holders of copyrights and other forms of intellectual property may unduly limit the ability of the public domain to incorporate and embellish creative innovation in the long-term interests of society as a whole, or create practical obstacles to proper utilization. These ideas underlie the case with which you're no doubt familiar, in which Robin mentioned in her introduction, a case called CCH Limited against the Law Society of Upper Canada, where law book publishers wanted royalties for the photocopying of books bought from law firm libraries. They sued the Law Society of Upper Canada, now the Law Society of Ontario, for copyright infringement, saying that anytime anyone on library premises photocopied a case from one of the library's law reports, or a case summary from a digest, or a passage from a legal treatise, they were guilty of infringing the publisher's copyrights. So too was any librarian who copied for a lawyer in rural Ontario who could not afford to drive the few hundred miles needed to Ontario every time they had to nail down a point of law. So I'll spare you the history of the case. That has had a checkered story going through the courts, but it finally ended up in the Supreme Court of Canada, and the publishers lost. The Supreme Court talked about fair dealing as an integral part of the Copyright Act, not just a defense. Like other exceptions, they said it's a user's right. In order to maintain the proper balance between the rights of a copyright owner and user interests, it must not be interpreted restrictively. User rights are not just loopholes. Both owner rights and user rights should therefore be given the fair and balanced treatment that befits remedial legislation. The Chief Justice in that case, who delivered the judgment, concluded by confirming that research applied to commercial and non-commercial users alike, and that it had to be given a large and liberal interpretation in order to ensure that users' rights are not unduly constrained. 3 later Supreme Court decisions double or perhaps triple down on the CCH case. In one decided in 2012, SOCAN, Canada's Musical Performing Rights Society, wanted online providers such as iTunes to pay for the snippets of music they streamed for users browsing online for recordings they might buy. The court agreed with the lower tribunals in dismissing the SOCAN case. Users would do research, and facilitation of it was a fair dealing. And another decided that year it wanted schools to pay for photocopying short excerpts from books for the use of their students. The Copyright Board decided the copying was not fair dealing and set a royalty rate, but the Supreme Court thought the board had misinterpreted research and private study and had also not properly weighed the fair dealing factors. It was the user's perspective, the students, on fair dealing that ultimately mattered more than the copyright owner's perspective. The board was told to reconsider its decision, which it later did by deciding for the schools. The third case, brought by Access Copyright against York University in 2021, hammered this message home. The question was whether the university's guidelines for producing course packs and other student material complied with fair dealing for the purposes of education. The guidelines were those developed by the Canadian Association of Universities and Colleges in light of its interpretation of the CCH case and the later Supreme Court decisions. They allowed the copying of short extracts for course packs, class handouts, or their internal electronic classrooms. Short extracts were further defined up to 10% of a work, a single chapter from a work, a single article from a journal, a single artistic work from a collection, an entire newspaper article or page, a poem or music score from a compilation, or an entire dictionary or encyclopedia entry. Instructor discretion was nevertheless required. Only what was required for the purpose could be taken. The Copyright Board and the lower courts, that's the Federal Court and the Federal Court of Appeal, all said the guidelines were too generous and did not amount to fair dealing. The Supreme Court on Appeal, unfortunately, did not decide the point on a technicality. Only copyright owners could complain of infringement, and Access Copyright, the only plaintiff, just held a non-exclusive license from the owners. They had no more standing to sue than a gardener hired by a landowner would have against someone trespassing on the owner's land. That, however, did not stop the court saying that the lower courts had got their fair dealing analysis all wrong by virtually ignoring the students' perspective as users, despite what the school's photocopying case had decided. Again, in Echoes of Mansfield, they emphasized achieving the proper balance between protection and access in the Act. For increasing access was, quote, a primary goal of copyright. Two factors probably contributed to the court's jettisoning of the language of exceptions and its adoption of the concept of user rights. First was the recognition that copyright law was about rights of expression, not just of authors and copyright owners, but rather everyone. From there, it was a short step to treat fair dealing itself as an aspect of the right to free speech, a right that the court had by the time of the CCH case already called a vital concept to be restricted only, quote, in the clearest of circumstances. The second factor was the insistence in the Universal Declaration of Human Rights of 1948 and other human rights covenants later on everyone's right, quote, freely to participate in the cultural life of the community, to enjoy the arts, and to share in scientific advancement and its benefits. The Declaration did also recognize the rights of authors to have the, quote, moral and material interests resulting from their scientific, literary, or artistic production protected. But significantly, that right follows the right to access. Once again, access is the rule and copyright the exception. And access has a greater claim to being a natural human right than does copyright, which after all is a right that can be bought and sold and is more often held by corporations than humans. I want to highlight 5 additional points that can be deduced from these and other fair dealing cases. First, a liberal interpretation of fair dealing led, in the iTunes case, to democratizing research, to include not just what academics and scientists do, but also research carried on by ordinary members of the public, even though some might call that shocking. In the school photocopying case, it meant that fair dealing for the purposes of the students' research or private study also included what teachers did for their students' benefit, and whether the research or study occurred in the classroom or the student's private room did not matter. Second, the longer a work and the more that is taken, the less likely will the dealing be fair, especially where it undercuts the copyright owner's market. That was what ultimately made the copying of the CSA's electrical code, in the case I mentioned earlier, the little guy from Alberta case, unfair. The copyright owner was unfairly from its sales being undercut by the copier's sale of the whole code. That does not mean that fair dealing cannot apply to copying whole works. How else can haiku or a photograph be criticized or reviewed? Also, if the ultimate dealing is fair, you may be initially able to take a whole work temporarily to use as the raw material for the ultimate work. If the latter is found to be a fair dealing, the taking of the whole can shelter under its umbrella. So in the United States, Google's digitization of whole books to enable them to be searched by keywords was held a fair use there. A potentially important point for data mining by AI. Third, the dealing must be fair in relation to its purpose and medium. Extracts that are unfair in length for a newspaper may be fair if used in a television news film. Fourth, dealings for mixed or multiple purposes are acceptable. Criticism remains criticism, even if its aim is also, or mainly, to amuse. The overall purpose is judged objectively. A user's sincere belief that they are criticizing is less important than whether the activity is in fact part of an exercise in criticism. Fifth, where a published work is involved, a fair dealing is concerned with the purpose of the use, not how the source work was acquired. Even with unpublished works, how they were acquired is much less important than how they are used. Thus, a couple of court decisions apply fair dealing even where a copy emanated from behind a paywall or involved circumventing a digital lock, the euphemistically named technological protection measure, suitably Orwellian phrase, a point that will no doubt be more fully debated in the AI litigation currently before Canadian courts. What of the future? I shan't say anything about the constant pressure parliamentarians and the government face from copyright lobbyists to cut down or eliminate user rights, except that the scenario is reminiscent of what preceded the passage of the first copyright law in England in 1710. Things sometimes, plus ça change, plus ça reste la même chose. There, as one source puts it, the stationers, the printers and publishers of the day, quote, came up to Parliament in the form of petitioners with tears in their eyes, hopeless and forlorn. They brought with them their wives and children to excite compassion and induce Parliament to grant them a statutory security. Nothing much has changed 3 centuries later, except that the lobbyists now usually leave their kinfolk at home. I shall instead mention 5 issues. Are user rights waivable? Can you contract out of them? Besides fair dealing, will the more general defense that a particular use is justifiable in the public interest become more prominent? Should Canada adopt US-style fair use? Will user rights apply to moral rights? And how will user rights interact with AI? Obviously, I could only speak very briefly about that. Parliament could, of course, clarify these issues by legislation, but I fear other things are occupying it at the moment. Okay, on the point of waiver or contracting out, I think we need a clear indication from the Act or a court decision whether user rights can be waived or contracted out of. Recent scholarly work suggests that the International Convention on Copyright, the Berne Convention, requires at least fair dealing to be treated as a mandatory right, unable to be contracted out of. A good argument can be made that our Copyright Act already complies with the convention by implication. If user rights are indeed, quote, as a fundamental requirement and essential part of copyright protection, as the Supreme Court has said, it's hard to see how they may be waived or modified, certainly not by any standard form, contract or click of a mouse. Otherwise, what the court has called the Act's central goal of disseminating original work, developing a robust, cultured and intellectual public domain, and sensitively balancing protection and access to copyright works, could be utterly frustrated. It's better that this be done by legislation rather than judicial decision, but as the UK has done it. But we'll see. Public interest, the fair dealing right tends to overshadow a couple of companion principles that do not appear in the Copyright Act and that are unwaivable. One is that copyright may be overridden for higher order reasons of public interest or public policy. The other one allows the right to be overridden for just cause or excuse. These principles are part of the general or common law and well alongside the Copyright Act. They provide additional safety valves to prevent copyright from going beyond its purposes or affecting activities that are more important than copyright, if one can envisage what those possibly might be. Suppose someone libels you in an email. Copyright law should not interfere with the recipient's right to forward a copy of the email to you, nor your right to make and circulate copies in good faith with an explanation in order to defend your reputation. You should not have to try to squeeze these acts of copying into fair dealing. You should be able to rely straightforwardly on what one English judge a century ago called your, quote, inalienable right to vindicate your reputation. Clearly nothing in the Copyright Act takes that away. Copyright may also be overridden where a work is injurious to public life, public health, and safety, or the administration of justice, as one court put it. We have a Canadian case like that, where a court in New Brunswick dismissed an engineer's claim that the structure of a building he had designed could not be modified without his consent, despite the dangers to public safety presented by his original design. Cases involving the administration of justice include copying material for use in judicial or administrative proceedings, copying a court's reasons for judgment, which anyway have little claim to copyright anyway, and no one doubts that a bank robber's plans may be copied to pass on to the police or the intended victim. There is, however, a need to clarify the scope of this defence because of some not very helpful case law going back actually to 1984. The federal government there was able to stop the publication of a condensed version of a lengthy government report on competition in the petroleum industry. The court thought that just making public information more accessible more cheaply was not important enough to justify even a non-competing publication. Perhaps fair dealing as it is currently understood could remove this blot on the jurisprudence. We have fair dealing restricted to 8 specific purposes, as I mentioned before, but this seems to me illogical and too constraining. The overall question should be whether any use is fair, whatever the purpose. Some countries, including Singapore and Israel, which inherited Britain's fair dealing criteria, have adopted a US-style fair use system with purposes that are illustrative rather than exhaustive. The adoption of some version of it in Canada would make fair dealing more conceptually coherent, and perhaps public interest offences outside the Act largely redundant. I actually think this is a matter of considerable importance for Canada's competitive position vis-à-vis the United States. Why should some acts that be done in the United States freely, especially in the field of electronics, and where in Canada they wouldn't fall under any criterion? So we've strapped ourselves to a old criterion which I think should be dispensed with. Moral rights. Besides creating copyright, the Act also gives authors and performers the right to stop their work being distorted or modified to the prejudice of their honour or reputation, and also the right to have their work attributed where reasonable. The fact that it does not explicitly make those rights subject to fair dealing or any other user rights seems an oversight. It's hard to see why user rights should not apply directly or analogically to moral rights. Moral rights have to balance the interests of authors, copyright owners, users, and the general public, just as copyright must. It would be odd, for example, if a parody that was a fair dealing nevertheless infringed the author's right to have his work not modified to his prejudice, to the prejudice of his reputation, at least where the author and copyright owner are the same person or their interests are substantially aligned. How user rights in their current form interact with generative AI is going to arise in the various class actions against ChatGPT, Meta, Anthropic, and others wending their way through various Canadian courts. The scale and complexity of the technology and the issues it raises go beyond anything Canadian case law has dealt with so far. Some of the problems disappear where the material mined and used by AI is used with consent. Google's terms and conditions give it broad rights to use material on its platforms, and other AI operators too have reached agreements with content providers. Without such consents, we need to see whether fair dealing covers what happens at both the input and output ends of the process. Let us accept that AI output is used mainly for research or private study or some other allowable purpose, despite the occasional deviation. Is it fair at the input end that AI indiscriminately copies masses of whole works without consent to achieve the relevant purpose? At the output end, would the work AI generates substantially reproduce an input that would compete with an identifiable copyright owner or harm their interests? Would moral rights of integrity and attribution be respected? Are there safeguards that minimize such adverse consequences or prevent misinformation or the creation and distribution of deep fakes? The US relies on its fair use doctrine to control AI mining, but the EU has gone the route of legislation in 2019. Their system is working, I think, only moderately well, and has also been criticised for not looking adequately after the interests of the authors on which the whole system relies. Again, it's better for Parliament to act sooner rather than later, so that people know where they stand without having to bear the enormous costs and delays of litigations. Let me conclude by echoing what I said in a lecture to the Copyright Society a few years ago. User rights do not set their sights on the author as a moving target. They instead aim to ensure that both authors and users benefit from the culture to which both contribute. The touchstone of fair use and fair dealing should be a fair deal, and that means a fair deal to all. Thank you for your attention.
Great. Thanks so much. That was an extremely interesting talk, and really accessible as well, very enjoyable. And So we have a little bit of time for question, and there are already a couple in the Q&A. The first one that came in, I'll read out and then just turn over to you, David, to answer. Since access copyrights defeat in the SCC in the Supreme Court of Canada in the York case, and in the decimation of its revenues from the educational sector, it is aggressively going after the corporate sector. So since access copyrights defeat, it's aggressively going after the corporate sector. The CCH decision made it clear that research is not limited to non-commercial or private contexts, and that for-profit businesses are entitled to the user's right of fair dealing for research. Why would business corporations need a license from access copyright for their normal research activities? And that's from Howard Knopf.
Hi, Howard. Well, it's a good question. As you know, access copyright has great aspirations, but they haven't done too well so far in the courts. I don't know. I can only think of situations where a corporation copies too much for a particular purpose that it's doing, that it wants to achieve. I think that it's a difficult case. I think the evidence will be difficult to produce. These cases very often turn on the evidence. In the schools photocopying case, as you know, one of the reasons the schools, the access copyright lost was that it produced no evidence showing that the publishers had in any way suffered economically from the copying. They would have liked a nice additional royalty stream, but it didn't affect their business, and educational photocopying, educational publishing continues apace. And so I think the short answer is they can aspire, but they have an upward ladder to climb.
Okay. And sorry, I said SCC. I got the wrong SCC there. Thanks. So our second question from an unnamed attendee is using the example of textbooks. Is a use of work from a large multinational textbook publisher that is deemed fair necessarily still fair if the book comes from a small publisher with a small market? How can we deal with how the fair dealing guidelines at Canadian universities impact local Canadian publishers and authors versus how they affect the much larger, much better resourced American publishers?
Very good question. And I think that, I think very good question indeed. I come back to the golden rule, right? I mean, I think you want Canadian content and Canadian publishing to flourish. Would it flourish more with restricted user rights? I don't know. I don't see it myself because certainly in the textbook market, we rely upon writers to write and use previous material. They build upon previous things. No work comes out of an author's head whole. It comes out in a social context with a whole mass of previous work. The person standing on the shoulders of a giant can see further than the giant. And we have an enormous giant of literature and culture there upon which we stand. And so I think all I can say is I don't have the evidence to indicate that the Canadian publishing is suffering as a result from the current user rights system. You can always put a case for saying, I'd like more. You can be Oliver Twist. But I think that I don't see the evidence that there is a major suffering in Canadian textbook publishing as a result of user rights.
Great. And a third question also from an anonymous attendee. Is the primary right of copyright holders to profit from their work? If so, would something like universal basic income, would something like universal basic income be a method by which we could expand user rights?
Well, great question. Well, I mean, that goes beyond copyright, doesn't it? It goes cuts right across everything. And yes, I suppose you would that would be a one way of supplementing the incomes of creators. We are already having an argument, or the government has already committed itself to providing an artist resale right, on the basis that they say that artists ought to benefit from the sale of, or the increased value or the increased price their works gets on the secondary market, so to improve their situation. And it's true that a lot of artists and painters and sculptors and all the rest don't get a lot of money. If you ask, do they rely solely on their income from creating? Very few of them do that. The problem with it, of course, in the artist's resale right, is that the ones that are going to benefit most are the big names rather than the smaller artists. But yes, I think that would be that's an intriguing question, and it would certainly, I think, help the user sector of the economy.
Great, thanks. That seems to be all the questions we have in the chat, but we're actually almost at the end of our time anyway. So perhaps I'll just ask if you have any final thoughts that you want to share in the couple of minutes left in the hour, or
No, I think I've probably shot my bolt there. I've probably provided enough fuel there for people to go home and argue about it for a little while. But I'm glad that you have this week. I think that it's a great subject to talk about and think about and discuss, and take into account the interests of not just users, but also the content industries that provide all this stuff. It's their interests do have to be considered. Otherwise, you've got nothing to use.
Well, that was really a wonderful tour. I very much enjoyed it, and I want to thank you again for your generosity in presenting to us. We're very fortunate to have had your time, and I think, as you say, people will go away and probably argue about it a little bit more. Oh, wait, we do have. Oh, yes, we have. Thank you. Yes, that's a good. Yeah, I will just. There's one last thing. I guess we wait squeeze one last one in there. Sorry, it just came in. Mr. Vaver suggested that material property and intellectual property aren't the same thing, and that copyright is not a natural right. He said something like, if someone throws your rose garden in the ocean, you can no longer have it. But aren't material property rights just as socially constructed as copyright and other intellectual property law? Well, that is a big question and a pretty interesting one. I don't know if you can.
Well, I'll reply to it in this way. There's property and property. There's the property as an institution which runs across so many things, and it's more often a label that you is a conclusory label rather than something that helps you reason to any result. But I don't think there's any question that intellectual property is different from land or goods and ought to be treated differently from land or goods for empirical reasons. It's not, as I said, the example I gave was a pretty crude one, but I think it made the point.
Okay, great. Well, thanks once again, and really terrifically enriching discussion, and very enjoyable as well. So thanks so much.
You're most
All right.
welcome.
Okay. Bye.
Bye-bye.